In 2010, Apple was preparing to launch the iPad and an e-book store of its own. At the time, Amazon commonly sold many new releases and bestsellers for $9.99. Publishers disliked that price because retailers, not publishers, controlled the final selling price. Apple offered a different system. Under its agency agreements, publishers would set the retail price, while Apple would receive a 30% commission. The contracts also included a price-matching provision, often called a most favored nation clause. In simple terms, Apple's store could not be left with a higher price than another retailer's store. That clause mattered because lower prices at another retailer could require lower prices in Apple's store. According to the court's findings, Apple and 5 major publishers used coordinated agency agreements that removed retailers' freedom to discount many ebooks. The publishers then moved major retailers, including Amazon, toward agency pricing. Prices for many popular ebooks rose from the familiar $9.99 level to $12.99, $14.99, or more. The United States Department of Justice and several state attorneys general sued Apple and the 5 publishers in 2012. The publishers settled their cases. Apple chose to go to trial. In 2013, a federal district court found that Apple had violated Section 1 of the Sherman Act by participating in and facilitating a conspiracy to raise e-book prices and eliminate retail price competition. This was not merely an allegation left unresolved. It became a court finding after trial. Apple appealed. In 2015, the United States Court of Appeals for the Second Circuit affirmed Apple's liability. Apple then asked the United States Supreme Court to review the case. In March 2016, the Supreme Court denied that request. The court did not issue a new opinion on the facts, but its decision left the lower court rulings in place and made them final. That result triggered a previously agreed damages settlement. Apple paid $400 million to e-book purchasers. Many customers received automatic credits through retailers such as Amazon and Barnes & Noble. The publishers had already paid about $166 million in separate settlements, bringing total consumer compensation to approximately $566 million. The lesson is not that agency pricing itself is automatically illegal. The legal problem was the coordinated agreement that the courts found had restricted price competition and raised consumer prices. A company may enter a market with a new business model, but when competitors coordinate prices instead of competing independently, antitrust law can turn that strategy into a very expensive court case.